If we could have your attention, thank you very much. And Dean Ray would like to say a few words before we get started.
Welcome back. Yeah, I have two messages today, actually three. And of course it begins with best wishes on the bar exam. We're all rooting for you. We all have confidence in you. We wouldn't have given you your diplomas if we thought you wouldn't be successful. And secondly, I want to congratulate you on being part of this program, because we've done studies every year, and attendance at these bar preparation programs is among the most significant things you can do to improve your chances, because there's a lot of things unique to the Florida bar exam that don't get covered anywhere else. And so I think you are doing the right thing. I'm happy to see you here. I'm happy you joined our law school more than a couple of years ago, and I was happy to see you graduate. And now we have this one more little hurdle, and by being here, you show you have the work ethic to succeed on that as well. And my final message is that I ask you to join me in appreciating the dedication of Dean Singer for all she does in reviewing exams, setting up these sessions, bringing in the speakers, and evenings, Fridays, mornings, nights, all those things. So thank you.
Remember that for those who are interested, we will do one more session next Wednesday from 1 to 6, or as long as you want to go, or as long as they let us stay in the room. We're up in the atrium. And what I'm going to do, I'm going to start, unless I hear requests for otherwise, I'm going to start with MBE subjects, because they form the foundation for so many things in Florida. And I can't possibly do a full review of everything in 6 hours. The idea is to give you an overview, to get you organized and thinking about the subjects in a way that'll help you attack both multiple choice and essays. If there is something in particular, though, that you would like to have me cover, then just shoot me an email, and I'll be happy to try to adjust accordingly. As I said, if I have 2 people, we'll run the session as long as the 2 people want to. I understand for those of you who it's the say, wow, it's the last week, I need to just keep my head down. Not a problem. It's there for those who wish. I imagine, well, I know Curleen sent you an email message. Here we have the earplugs. So is there anyone who didn't get earplugs who wants them? We're all good? Okay. And this box will go up to Tampa, so there will be earplugs available. We don't know yet exactly where the STU room is going to be set up, and so we can't tell you yet. Career Services is trying to get some answer on that. Once they do, we'll try to circulate it to you so you know where the lunch is going to be, and also where, if you have something that you brought, we don't recommend that you bring it in there, but if you bring in something, we'll be able to tell you eventually where the table is so you can leave it there. Anybody have any questions about anything besides substance before we jump into the substance? You're all good? You all know what you're doing? Everybody's leaving early enough to not get stuck in the rain or whatever else, right? Okay, don't wait till the last minute to get there, because it's Tampa, and if you're driving, you got to go across Alligator Alley. Well, 75, but it's still Alligator Alley. And if you're flying, who knows what the weather's going to be like in the rest of the country. So just word of advice there. All right, what we're going to do today, we're going to do 3 topics. I'm going to start with the family law because for 2 reasons. It's easier than perhaps the Florida Con law. And also, as I mentioned before, I think it's something they might test. And I really spent some time this week thinking about how they could work dependency into it. And what came to mind, it's interesting, I was thinking back over past questions on the bar exam. And one in particular came to mind from a while back now, in which you had a husband and wife, they're getting divorced, they had a child, and the wife took the child to live in a cult. And the cult was involved in snake handling. You were thinking the same thing?
All three of us were talking about that like 15 minutes ago.
Okay. So if you were talking about it, then you guys know that you could easily work dependency into that, right? Besides the fact that you're going to have to talk about whether the wife should have some parental responsibility, if she's involved in an activity that puts the child in danger, that can raise dependency issues, right? Was that the conversation you were having?
No, we were talking about the snake handlers and free exercise.
Well, yes, and all that's there too, but you see what can happen. They could put that, that type of question and bring in the dependency, which they haven't tested yet. So that's another reason why I think you want to be prepared for family law and look for some kind of angle like that that will combine family law with dependency, because they're not going to give you a dependency essay standing by itself. I can't imagine that they will. But be on the lookout for something like that. Now, the question we're going to do today, however, doesn't have any snakes in it, and so there's no, and there is no dependency issue. But I like this particular question for a lot of different reasons. So I'm going to ask you, actually, you know what? Why don't we, if I get my packet, hang on. Why don't we kind of look at the facts together? So pull out that packet and go to the back. And the reason I'm going to do that today instead of having you read it first is because we have 3 topics. So I want to make sure we don't go too long today. Now, it starts out with husband and wife. They met in college and they married after graduation. Well, to me, right away, I know where this question is going. It's got to be a family law question, and they're going to get married, and then she is going to put him through school, and then he's going to divorce her, and it's the typical pattern that used to occur. Now we have equal opportunity, right? Because you write this question today, and it could be the wife who divorces the husband after he puts her through school. But at the time this question was written, it was a fairly standard pattern, if you will. Now, what I want to ask you to do, if you get a family law question, try to put your personal experiences aside and do not let them creep into your answer. You'd be surprised, or maybe you wouldn't, at how angry some people get when they write family law questions. If you have had an unfortunate experience, or if you're just really moved by the fact pattern, be as cold, as clinical as you can. And you laugh, but I'm telling you, you would be kind of surprised at what some people say in these questions. And normally what happens is I can just draw a line right down the middle of the room, women on one side, men on the other, and the answer is divided accordingly. So you want to try to be, again, as clinical as you can. Notice that the first sentence here doesn't tell you where this question is set. Eventually, we get down a little bit farther, it says they have a home in Tampa. So what you want to do, if you have a question on the essay portion that is not clearly labeled as a federal constitutional law question or something like that, then tell them in the first sentence that you're going to assume it's set in Florida. Here we can base that assumption on the house in Tampa, but they are looking for you to use Florida law, so just kind of give them that heads up that that's what you're assuming. Husband attended medical school while wife worked in the local department store. Besides setting up the eventual divorce that's going to come, why is that sentence there? What's it telling us?
She provided the support.
Okay, she supported him. Where might that be relevant? Okay, alimony, equitable distribution. Remember, and make sure when you are writing your answer for equitable distribution, for alimony, for parental responsibility, there are a lot of statutory factors. And who paid for what, at least in terms of equitable distribution and alimony, that's a factor to be considered. When you discuss those issues, make sure that you mention that there are statutory factors. You might not have memorized all of them, because there are a lot for each category, but at least say there are statutory factors, and try to match factors with facts. The facts will help you remember what the factors are. You'll see when we get to my answer that I list them all. Again, it's a study guide, but you should at least say there are factors, don't forget about them, and then try to use them to a certain extent. Wife had been accepted to law school, but she decided to get a job instead to support husband. Well, of course, it's going to suggest, number one, that she gave up her career, and what else might it be relevant to? Alimony, what kind? Rehabilitative alimony, absolutely. So you're making those notes as you go along, using those facts. The facts are all there for a reason. Husband paid his medical school tuition by withdrawing money from a trust fund which husband's parents had given husband before his marriage as a graduation gift. Okay? What's that trust fund doing there? What kind of property is it? It's non-marital property because he got it before they got married, and you're going to see that he pays. They use money from the trust fund to buy the house, and mortgage payments and taxes are paid from the trust fund. Does that make the trust fund itself marital property? No, just the funds that were taken from the trust fund and used for those purposes. The rest of the trust fund remains non-marital property. Wife paid all of the living expenses while husband attended medical school, again showing her contribution to the marriage. 4 years later, and I got to back up a second. Well, we can do it right here. 4 years later, husband graduates from medical school. His license, which he eventually gets, marital asset?
No.
No, but you
His
want
medical license.
it's not in Florida. It's not in any state but New York. So you want to indicate that that license is not a marital asset. If a spouse has a business that has goodwill, the goodwill could be a marital asset if they develop the goodwill together. And I've seen questions where they brought that up. But the degree, the license, neither one is by itself a marital asset. Wife quits her job. She stays home, raises the couple's 2 kids. Dean?
I'm sorry. This goodwill thing has been driving me crazy.
Okay.
How do they divide it? Just note that it is marital property and that she used some of your property
Yeah.
for, or
Yeah,
whatever it is?
exactly. The good news for that particular question is you can't take a calculator into the exam, so they can't get too complicated. At best, you would just say what you just said. Yeah. All right, so wife quits her job. She stays home, raises the kids. What's that doing there? Contribution to the marriage, right? And now, of course, we know we have 2 kids, so we're going to have parental responsibility.
Sorry, the house.
Mm-hmm.
The house is
Oh.
marital property.
Okay, good question. The house, and it's one of the few places where the question isn't as precise as it should be, and perhaps it was done that way on purpose. Do they tell you how the house is titled? Nope. Well, you're going to have to make an assumption here. I don't usually recommend making assumptions, but you have to. And probably they're asking you to assume that they took as tenants by the entirety. If the house is titled in his name alone, yeah. But if they take as tenants by the entirety, which is what I think they are assuming that you're going to assume, then is it marital property? Yes, it's presumptively marital property anytime property is taken as tenants by the entirety. And even if one spouse uses separate property to purchase that tenancy by the entirety property, that one spouse who uses his or her own money, husbands in this case, is presumed to be making a gift to the other spouse. And interestingly, not surprisingly, at the time this question was written, there was a case that was moving its way up to the Florida Supreme Court. There were different opinions in different DCAs moving up to the Supreme Court to be resolved on this particular point. So they clearly were testing something that was an issue in Florida.
And so the $200,000 is converted into merit, I mean,
Well,
it's,
yeah.
you don't
'Cause
need to worry about that.
No, you really don't have to.
And then not to make it like too complicated,
Yeah.
but like say in the background they give you something like the house appreciated in value.
Good point. If the house appreciates, now, first of all, if it's tenancy by the entirety, the house itself is going to be marital property, so any appreciation is going to be marital property too, right? Suppose, and I've actually seen kind of variations on that theme, suppose that the house was titled in husband's name alone. I don't think that's what they intended, but suppose it was, and it was deemed to be separate property. Could the appreciation in the house be marital property? Yes, if?
Yes.
What's the if? If they work together to improve it, right? And I've seen questions where the wife did, the redecorating or something like that.
So the wife would get funds from the improvement and from the appreciation.
Yeah.
All right. Thank you.
All right. Husband, of course, becomes a successful doctor, but she doesn't get anything from that unless there's goodwill from his practice. Husband works long hours and didn't spend much time at home. For their 15th wedding anniversary, husband bought wife a $40,000 sports car, which is? It's an interspousal gift, use the full term. And as an interspousal gift, it is marital property. Ah, yes. Interspousal gift during the marriage is marital property. Wife appreciated the car, but really wanted husband to spend more time at home. Anybody know why they put that fact in there, or why I think they put that fact in there? What are you going to do with marital property, usually? Split it down the middle, right? That's equitable distribution. But you can do a lump sum of certain items. Sometimes happens, for example, that one spouse wants an asset like, not in this case, but the facts may tell you that wife wants to keep the house. If she had said she wanted to keep the car, that could be a partial lump sum in the settlement of the marital assets. And so she'd get the car, and you'd make up the difference some other way. But here, she doesn't want the car, so they're going to sell the car and split the proceeds from the sale. Remembering always, take your clue from the facts. Husband's absence from home was due in part to an adulterous affair he was having with nurse. Now, it used to be, up until fairly recently, I would tell you, not relevant unless it depleted marital assets, but we know now that, fill in the blank. Well, the evidence of the adulterous affair is relevant to?
The distribution of marital.
Not marital assets, but alimony. It's a new factor in respect to alimony, relatively
Does it
new.
only apply to alimony, or it applies to just
Oh,
how they'll decide?
well, it's a new factor that's enumerated for alimony.
Oh.
But could it be taken into account in equitable distribution? Remember, there's that catch-all for equitable distribution that says anything else. And then you, as far as I can tell, and I've actually done a little bit of research on that point. If anybody knows differently, who has more expertise in family law, let me know. But as far as I can tell, that rule that says that marital misconduct is taken into account only if it depletes marital assets still appears to be the rule. So, number one, could you take the marital misconduct into account in respect to equitable distribution under the catch-all, anything else? Yes, if it depletes marital assets. And while it's listed as a factor in respect to alimony, probably still you want to show that there's a depletion of marital assets, which you don't have in this case, because you didn't buy nurse any gifts. At least they don't tell you about any. Okay, shortly after their 15th wedding anniversary. Now, at the time this question was written, it was like, well, whatever, 15th, 50th, we don't care. But now, we care because?
The alimony changes.
Alimony depends on the duration of the marriage. Yeah, exactly. And 15 years is going to be what kind? Moderate, yep. Up till 17. at the time of filing, husband and wife are 37 years old. Why did they tell you that?
Young enough to do a new.
Okay, that's part of it. And if they're 37 years old, they're probably in good health, right? So you know, use those facts. Daughter is age 11 and son is age 8. I think that was written that way very specifically from my perspective. What do we know about kids in respect to parental responsibility?
18.
Well, no, well, yes, but
They can decide after 12.
well, it's not that they can decide. There's no bright line, but the child's preference can be taken into account if the child is old enough and mature enough to make an informed decision, if you will. An 11-year-old girl, girls mature, sorry guys, earlier than boys. And so an 11-year-old girl might be mature enough to make some kind of reasonable choice. But an 8-year-old boy, not so likely. So they were actually asking you to consider the age and the sex of the kids. Okay, now, call of the question. The following issues that may arise in the divorce action and probable resolution: 1, distribution of property; 2, alimony; 3, child custody today, parental responsibility, right? Always use the PC word; and 4, child support. The call of the question is specific. Answer the call of the question in the order that the questions are presented. The good news is, whoever drafted this question put the issues in the right order. And there's case law that says that what you're supposed to do is divide the assets first and then talk about alimony, child responsibility or parental responsibility, and then child support. So if the call of the question is vague, which it's not likely to be, but if it is vague, use this order. The only time you would not use this order is when, and I've actually seen it on occasion, if the call of the question puts these issues in a different order. So then, even though the call of the question got them in the wrong order, follow the call of the question. So let's go ahead and start now and take a look at what we've got going in this question. So I start with equitable distribution. And I threw in antenuptial agreement. Honestly, unless you want to put a sentence or two, I wouldn't spend a lot of time in this question on a pre or a post-nup agreement, because there isn't one. But it's a little bit of a checklist here, right? So always think about it, because if you have a pre or a post-nup agreement and the parties have already divided up the assets, then as long as that agreement is enforceable, you'll follow the agreement. Then our rules for equitable distribution and the distribution in this case. So marital assets. Now, as I mentioned before, you know, I'm listing everything, even if it's not raised by these facts, for study purposes only. You can go directly to the categories that are raised by the facts. You don't have to recite everything that you know about marital assets, because that, you know, it gets kind of boring after a while. But we see all the different kinds of categories. Remembering also, distribution must be equal unless unequal treatment can be justified. And I will tell you this, case law makes it pretty clear that you just divide it down the middle for marital assets, and then you make up for inequities in alimony. It's a rare case where the equitable distribution is done on an unequal basis. That's the exception, not the rule. So my advice to you would be, discuss the categories, discuss the factors, but then just say down the middle, and then try to remedy, for example, in this case, wife's problems through alimony. So what do we got? Anything they get during the marriage. In this case, they didn't get anything during the marriage. So I listed here, but you probably wouldn't even have to talk about it on the question. We already discussed enhancement in value. Obviously, if it's a marital asset, you're going to include the enhancement in value. And even if it's a non-marital asset, but the enhancement comes from marital efforts. Interspousal gifts. Now notice what I do right here. Try to get law and fact together as much as possible. big blocks of rules followed by big blocks of facts. That does not equal analysis. It's when you match law to fact. So interspousal gift, husband gives the car to the wife during the marriage. We see clearly that we have an interspousal gift. And retirement plans, not relevant here. Tenancy by the entirety, remember, we have that presumption. And in this case, and just kind of a refresher on this particular rule could be relevant in a family law case, question could be relevant in a property question, could be relevant in a homestead question, could be relevant in a wills and trust question. Know the rule. In Florida, a conveyance to two persons who are husband and wife is presumed to be tenancy by the entirety, even if they aren't named as husband and wife. And you do not need to, once again, you don't have to name them as husband and wife. As long as you make that conveyance to them, we're going to presume a tenancy by the entirety. And of course, the case that I mentioned, Robertson versus Robertson, said that even if one spouse uses his or her own assets, the trust fund in this case, to purchase property that is then taken in tenancy by the entirety, the spouse who uses his or her own money is presumed to be making a gift to the other spouse. And there's absolutely nothing in the fact pattern here to rebut that presumption. And everything to the contrary, it looks like husband was making a gift to wife.
Just a little confused. On the fact pattern, he had a $500,000 trust fund. He took $200,000 out. Let's assume the house appreciated in value to make the math easy, say $300,000.
Okay.
And so at that point in time, there's a divorce. He would get to 200? No,
150.
150.
Because you said it appreciated to 300, right? 150, she gets 150.
But if he owned the house beforehand,
If he owns, right, if he owns the house in his sole name before the marriage, and he does not convert it into a tenancy by the entirety, what do we think? Is it marital property?
but the appreciation is.
The appreciation
assuming
could,
that she
yes, that's
contributed.
correct.
Okay.
That's correct. Yeah, and you can see the variations on the fact pattern, so we can kind of keep that in mind. It's a really easy thing to test, and something they like to test. So, be prepared to address that kind of issue in a family law fact pattern. So in this case, again, I set out the category and the rule, and I immediately analyze it, keeping law and fact as close together as I can. My conclusion is, yeah, I think the house is marital property. If you decide it's not, you're going to have to say because the facts show enough to rebut the presumption. I don't think you have it here. The actual conclusion is less important than how you reach it in this situation. So, non-marital assets, here, of course, anything you get before the marriage. And the trust fund itself, minus whatever is spent, obviously, on the marriage, remains his separate asset. So whatever's left over in the trust fund, he gets to keep. And that's the only non-marital asset they've given you here. But of course, gifts that either spouse receives, inheritance or gifts that you get during the marriage, if it's just to one spouse, non-marital asset. We don't have that here. Now, factors. Make sure that you at least mention that there are statutory factors. I list them all, and where they're relevant here, I've matched them up with the facts. So we start with the contribution to the marriage by each spouse. And wife contributed by being a homemaker and by working for a while. And husband, he contributed some money. Not much else, but he contributed some money. So each contributed something. Economic circumstances of the parties. They made that very clear here. Husband has all the money and wife at this point has none. Duration of the marriage, which of course is going to become important when we get to alimony. Interruption of personal career. Well, there you go. Wife interrupted her career, her education, and her career. contribution of one spouse to the personal career or education of another. There you go. Wife supported husband while he was in medical school. And notice the difference so that you don't get confused. She has no interest in his degree or in his license. But it is a factor that can be taken into account in equitable distribution. It's also a factor, obviously, that can be taken into account in alimony. And so really what happens is, although in almost every place but New York, that degree is not a marital asset, still, most states, there are a few like Colorado where you run into problems, in most states, you're still going to be able to compensate the other spouse in another way. Desirability, this can be an important one in this case. Desirability of keeping a marital asset whole. And here's how it plays out in this case. Wife didn't ask for the house specifically, so we're not going to have a lump sum with the house. But what's likely to happen is that they're going to preserve the house as a marital asset until the kids reach 18. Because they've always lived in that house, they've always gone to the same school, and so somebody is going to live in the house, probably wife, with the kids until they reach 18, and then they'll sell the house and divide up the assets. So that's what this factor is talking about. We talked about the contribution of each spouse to producing income, so we've already covered that one. And in particular, the desirability of maintaining the marital home. Look at the facts. This case is set up to want to maintain the marital home. Sometimes they're not, but clearly in this one, it makes sense. It's equitable to do so. It's in the best interest of the kids. And it's financially feasible. An important issue. In this case, can husband afford to pay 2 mortgages? It looks like he can. So you could probably, he'll live wherever it is that he lives with nurse or whoever else comes along, and the wife will live in the house with the kids until they reach the age of 18. See if there's anything else. And once again, our catch-all. Dean, you have a question?
Practically speaking, are the factors more for determining non-equitable distribution?
Yeah.
Right, I have it right in my head?
Yeah, right. So you're going to,
Assumption of equitable.
that's right. And if something is terrifically out of whack with one or several of these factors, then a court could do 60-40 or 70-30 or whatever. The likelihood of the court doing anything other than 50-50 is relatively slim in the usual case. But even though it's unlikely that you're going to upset 50-50, for your purposes to show that you know what the law is, do the exercise of the factors. And then should you find one to be so significant, then you can say, we're going to change the allocation. Once the conclusion isn't as important as how you reach it. Okay, so then I sum up. You know, always in an essay, here's where I'm going, now here's where I am, and then finally here's where I was. So here's where I was. Husband gets to keep his trust fund. The car is going to be sold and divided up. The house will be maintained for the kids until they reach 18, and then you'll sell it. And that's pretty much it in terms of the assets they've given you. Any questions so far? All right. So what do we do next? Alimony. Okay. Which, of course, has changed over the last couple of years. So types of alimony, statutory factors again, and then award in this case. Now, once again, I list all the types of alimony. It's one of those places where I might, in an introductory paragraph, even though some of these are not relevant, like bridge the gap isn't really relevant here, I might just list them all anyway. Personally, I'm not real big about just here's everything I know. But an introductory paragraph that says we have these kinds of alimony and then zeroing in on the ones that are relevant in this case, that's maybe not a bad idea. And notice also, put it in parentheses. I find it kind of interesting. The statute doesn't actually mention temporary alimony. I don't know why, but it appears that the court has to have power still to order temporary alimony, and they're doing it. So the reason I put it in parentheses is because it's not in the statute. Okay, remember again, it can be periodic payments or lump sum, and I just gave the date, which at this point now, since we're into 2014, we're almost 4 years into this new scheme. All right, so, I'm sorry.
Question, from a practical perspective, if there are children involved, typically, I wouldn't see the court giving a lump sum benefit or alimony.
Yeah, probably not. Yeah. I would mention that the court has the power, but you'll see in my my distribution that it's not lump sum. Lump sum payments tend to be given if you have, for example, if they tell you that husband is suffering from cancer and he's going to die next year, something like that. If you have the spouse who's going to make the payments either going to kick the bucket or likely to skip town, that's when lump sum might be a good idea, right? But here, there's no indication of that. All right, so bridge the gap. I mentioned it. Be on the lookout depending on the fact pattern. I don't think it's relevant here because there are going to be other things. I mean, maybe you could give her a little bit of bridge the gap. I'm not saying you can't. But it's going to be short term, 2 years, and of course, here's some of the rules. Rehabilitative alimony, however, it's important in this case. Why wife would want to go to law school, I can't tell you. You're all probably thinking the same thing right about now. You escaped, don't go back into that den. But should she wish to rehabilitate herself and get a law degree, then of course the money should be given to her. Because she's not redeveloping skills, she's getting new skills and skills that she had once desired. Notice, it's a change at this point. It's been around for a while. You have to have that rehabilitation plan, though. You can't just award rehabilitative alimony and then say, well, good luck. She has to show, so she'd have to come forward and say, I'm going to law school. This is a law school that I hope to get admitted to, or I'm already admitted to, or was admitted to in the past. Here's what it's going to cost me. Here's how long it's going to take me. And here's what it's going to cost me to take the bar exam, right? So all of that has to be in the plan. Otherwise, no rehabilitative alimony. It's peculiar. Sometimes I see people saying you can't modify rehabilitative alimony. Of course you can. Think about it for a second. Suppose wife says, okay, I'm going to law school. And then she gets to law school, and the first week she goes, geez, I don't want to do this. And so she comes to her senses, right? And she quits law school. Well, you're going to modify or terminate that award, right? Or suppose she comes to St. Thomas and she starts out with that full load. You guys didn't have this option, but the first year class, they can do the flex schedule, and it's designed, for example, for someone with kids. So then she's doing the flex schedule that could affect the rehabilitative plan, and so modification of rehabilitative alimony is always possible. No facts in this case, but again, just to be aware of. Durational alimony. What do we think in this case? It's probably what she's going to get, durational alimony, because she's not going to qualify in terms of the number of years of the marriage for permanent alimony. And there is there's a movement afoot, not going to affect you on the exam, but they're trying to fiddle with these categories again. They're constantly fiddling. And some people would like to do away with permanent alimony. Once again, not going to affect you as you take the exam.
Given the age of the children, does durational alimony play into that?
Well, the other way around. The age of the children, could it play into durational alimony? Right. Yeah. The answer is yes, it could. And we're going to get to factors in a moment, right? Remember what I said. For everything except for child support, you have the categories, and then you have the list of statutory factors, which overlap a lot. You see a lot of the same factors, whether you're talking about equitable distribution or alimony or parental responsibility. But make sure you mention them each time because the statute lists them over and over again. Okay, same thing with durational alimony. It's not forever, and it's going to end when either party dies or if the party receiving alimony remarries. And you can modify and terminate. Now, permanent alimony, that's when you need the marriage of long duration. And of course, in this case, it's going to be moderate, as we said before, because it's 15 years. And I didn't say too much about it other than to list the rules. So remember, short term is less than 7 years, moderate from 7 years up to 17, and we have 15 years here. Where are my factors? Okay, factors again. Standard of living, which of course is going to play into durational or permanent. It appears, since husband was a doctor and it looks like he was relatively successful, that the standard of living was fairly high here. So that standard of living can be taken into account in determining how much money wife gets. Duration of the marriage, we just talked about. Age and physical and emotional well-being of the parties. In this case, they both seem to be fit. Look out for facts that show one spouse who is physically or mentally disabled in any way. Financial resources of each party, clearly again, husband has the financial resources, and at this point, wife does not. Earning capacities, same thing. Husband's got all the earning capacity right now, and unless and until she gets some kind of degree, wife is limited in her earning capacity. Contribution of each spouse to the marriage, important of course. And remember that while husband made a financial contribution, wife did everything else, and she made a financial contribution early on before the kids came along. Going back to Frank's question earlier, responsibility each party will have in regard to the children that they have in common. There's your statutory factor that goes directly to your question. Tax treatment, I've never seen them really go into tax treatment. I can't imagine that they will, but just be aware that that can be taken into account. And of course, other sources of income available. Don't forget, husband still has that trust fund. Here's our adultery. And remember what I said. You notice when we went through the statutory factors for equitable distribution, there's no mention of adultery. But here, and it's, again, a relatively new addition to the statutory factors for alimony. Adultery is actually spelled out, probably, as far as I can tell, and as far as people who know have said, you're still going to use that rule that says you take it into account only if it has depleted marital assets. And our catch-all, any other factor. So I wrap it up, and you can do the alimony any way you like in the end, as long as you go through the steps we went through. It doesn't really matter whether you give wife bridge the gap and durational and rehabilitative or just rehabilitative or whatever. The only thing I wouldn't do here is give her permanent. I don't think the fact situation justifies permanent because the marriage is 15 years. Okay, so now we get to parenting responsibility. And notice I use the PC term here. People still like to write about custody, but that's not the right word in Florida. So try to use the language and talk about parenting responsibility. Now, one time in your exam, you should say best interest of the child. But I see people, and you may be laughing because maybe it's you, who begin every sentence or every paragraph with best interest of the child. Don't overdo it, right? Because it gets annoying. And we talk about shared parental responsibility today, and we have that very important parenting plan. And then, don't forget, statutory factors again. So, notice this little sentence here. I'm not a big fan of memorizing stuff, but you probably do want to begin this section with a sentence that looks a lot like that. Notice, best interests of the child, and the statute says in conformity with, guess what, the UCCJEA. So if you want to sound like you really know what you're talking about, that's how you start. And by the way, this question doesn't have jurisdictional issues in it, but they do like to test UCCJEA. So if you're not familiar or comfortable with it, do brush up on it. So the idea, of course, now is that parental responsibility is shared. So avoid, at least in a fact pattern like this one, avoid giving the kids to one parent and that's it and we're done. Now, maybe if you have the snake handling case, that's what you do. But in a situation like this, you would not say wife gets the kids and husband gets to visit them occasionally. They will have shared parental responsibility. And of course, the desires of the parents and the desire of the children if they're old enough. So, the parenting plan, really important. It's not they can if they want, they must. And who prepares the plan? A lot of times I see people suggesting that the court prepares the plan. Think about it. First of all, you don't want the court to prepare the plan for you. And the court's not going to sit down and take the time to prepare the plan. The court will sanction the plan once it's prepared by the parents. They're the ones who have to sit down and do the hard work. And it is, from what I understand, really hard work. Number one, to come up with the plan, and number two, to make it work. So do not underestimate the importance of that parenting plan in the process and especially in your answer. So what do they have to do? Here are the things that you have to include. How are they going to share responsibility for daily tasks and time-sharing arrangements? Who's responsible for what? And interestingly, how are they going to communicate? Are we going to do this by email? Are we going to text? Are we going to go on Facebook? What are we going to do? All in a lot of detail. Now, they're not going to give you a whole lot of facts to work with, so you're not going to have to spend your whole time writing a parenting plan. But knowing what goes into it and how detailed it needs to be, that's something you do want to write about. And then, of course, remembering again, UCCJEA. It comes up over and over again. When is that relevant? Of course, if one parent's going to be in one state and another in another. So then, once again, factors. Don't forget about the factors. We're going to look at each parent and how likely is the parent to foster a good relationship with the other parent. There's nothing in this fact pattern that suggests that that one or the other, husband or wife, is going to keep the kids away from the other spouse. So that's the good news. But you take it into account. You also look at how likely are the parents to actually carry out the responsibilities, or are they just going to delegate them? So, for example, husband's really busy, and he's busy with his medical practice, he's busy with nurse. Is he just going to hire somebody to sit with the kids when they come to his house? Or is he going to spend the time with them when they come? We look at things like, again, how old are the kids? What kind of relationship did they have with each of the parents before the divorce? Where did they go to school? Where are they going to, continue to go to school? All of those things are taken into account. Right there with the length of the stable environment. Geographic viability of the parenting plan. I know folks who are shuffling kids back and forth, up and down the Gold Coast now, up and down in between Dade, Broward, and Palm Beach, and maybe beyond. It gets a little nuts. We've got a long state, so it's unlikely that the plan is going to include another state unless you start out in Tallahassee or something like that. But they do like to test parents in different states. So, I've seen questions, for example, where one parent's in Florida, another in Georgia. So just keep that in mind.
That could be jurisdiction, could come in from there too.
Absolutely. Absolutely. The UCCJEA could easily come into play if one is in one state and one in another. We look at the moral fitness of the parents. Nothing here to suggest that there's a problem. The snake handling case, that's where that might come into play. Mental and physical condition, they're both in good shape. And home record, school record of the kids, are the kids into their school? Are they doing well? Are they involved in activities there? Then we look at the preference, if they're old enough, and once again, if you think that the boy is old enough, not a problem, as long as you couch it in terms of the ability of the child to voice the preference. A lot of this is starting to repeat because we want to know how informed the parents are. Wife knows everything here. Husband doesn't really, it looks like doesn't know much about what's going on, but he should be able to communicate with the kids and communicate with spouse, with his ex-spouse. And that's what we have next, the communication, which is important. We look at parenting tasks that each customarily performs, which can be important because, for example, wife lives at home with the kids. She's probably the one who drives them to school every day. But parents divide up those responsibilities sometimes. So maybe wife drives the kids to school in the morning and husband picks them up after school, or husband is the one who takes Johnny to soccer practice. Those kinds of things can be taken into account. I don't know if there's anything else I want to stress here. Always we have a catch-all. So just take the time to talk about some of the things that will be taken into account in making that parenting plan, using the facts as your guide. Anything in there that can help you. Talk about how the husband and wife will divide up parenting responsibilities. Use it. Remembering again, though, unless you've got that snake handling case, maybe that's one of the few where you don't give joint parental responsibility. It's almost always going to be the case today in Florida. Child support, our last issue. Remember, of course, each spouse has a duty to support. And here we have statutory guidelines. The good news is, do we have anybody out there that's actually worked with those statutory guidelines? Anybody ever seen them? Goes on forever and ever. It's a very detailed table of the guidelines for determining child support. You don't have to memorize all of that. Not a good idea. Some general parameters. That's all that you need because you don't want to clutter your brain with stuff like that. So remembering again, each parent has a duty to support, and we have to, the parents have to prepare a child support guideline worksheet. That's the kind of thing, again, that you want to write. You don't have to prepare one in your answer, but at least state that the parents need to prepare the worksheet. And they're going to have to swear to their income, of course, and document what income they have. We impute income if the parent doesn't properly report. And then we go to the statutory guidelines. If we are less than if the combined income is less than $800 per month, then child support's decided on a case-by-case basis. If you're in the middle range, $800 a month to $10,000, remembering that's combined, which is $120,000 annually combined, then we just use that statutory table that I mentioned, and that's all you would have to say. If you're over $10,000, then it's a combination of factors. You've got a percentage which you then have to adjust depending upon how many children there are. And if you can say that much, you're in the driver's seat. Remembering, of course, though, that the court has discretion to vary. Most people remember the plus or minus 5% rule, right? That's something that sticks. Mention it. Court has that discretion, thank you, depending on stuff like extraordinary medical or other kinds of expenses. If you've got a child actor, independent income of the kid, things like seasonal variations in income, if perhaps one of your spouses is someone who fishes for stone crab. Okay, it's seasonal, and the income comes in at a certain part of the year. You look at the age of the child, remembering that the older the child gets, the more likely it is that it's going to cost more for the child. Because a little kid, it's just a little kid in the crib, but then when they start to get to the age where they need braces, where they need glasses, where they're involved in sports at school, and so they need the uniform and stuff like that. I wouldn't worry I include this stuff again as study more than anything else. There's a lot of detail here that you might not want to clutter your brain with unless it's something you already know. If you do, by all means use it, but the stuff on this page you probably don't want to spend a lot of time learning. This one, though, mandatory variance, it's a relatively new addition to the statute. I would include it because the court must vary from the guidelines. Let me see if I can say this. I was trying to summarize it and not doing a good job. So remember again, the court must order support that varies from the guidelines. You use a formula if the child is required by court order or whatever to spend a substantial amount of time with the obligor spouse. So if one spouse has the kids all the time, then the court must vary from the guidelines. They won't make you do the calculation, but include a sentence about it. It's probably a good thing. So both husband and wife have an obligation here, and that's about all I would say in my conclusion, because they don't give you anything that allows you to reach a dollar amount. Any questions? Dean, you're thinking?
What is this so-called joys of childbearing? That's just...
Well, I'll leave you to ponder that one and ask your parents. Or those of you who are parents, depending upon the age of your children. Okay. Do you want to take a break now, or do you want to talk about Florida evidence and then take a break? Your pleasure. We'll take one break, either before or after Florida evidence. And Florida evidence, probably half hour. You want to just go for it, and then we'll take a break?
Yeah.
Okay. All right, so now you need your Florida evidence questions and your clicker. So turn your clicker on. I have a set of questions. It doesn't do every Florida distinction, but it does most of them. And then there are a couple. One, while you're setting up, I'll go ahead and talk about. And the most recent change, a significant change. If they're going to test Florida evidence, you know it's going to be there. The change from Fry to Daubert. Oh, yeah. That's a biggie. And I don't have a question on it, but I tell you, make sure that you remember that we are now, as of last July, a Daubert jurisdiction, right? We were one of the last holdouts with Fry.
And that applies to expert witnesses.
Expert testimony, yeah. And you know, with Daubert, you're looking for relevancy and reliability, right? And the generally accepted requirement, which was Fry, is now a factor, but only a factor in determining reliability. All right, so Oops. Well, you know the drill at this point. We're going to do, and here, because it's just a few questions, we'll do all of them. So go ahead with question number 1. Yeah, you're not registering, Tamar. Let's get you another one. Well, go ahead and try with that one. Wow. The receiver's over. Try pointing it over here tomorrow. I don't know why you're not. Wow.
No one is moving.
Wow. Oh, okay. Oh, it decided to disconnect itself. Why? It's connected. Okay, let's try this again. Hang on. Lost connection. Yeah, right. Retry. Come on. All right, let me. All right, I don't know what to do here. Okay. Yeah, I know. Lost connection. Retry. Okay, it connected now. Let's give it a moment. Scanning. Can't get rid of this. Yeah, come on. You may have to take that break. Hang on. Let me close it and start it again. Doesn't even show it. Okay. This new system's great, isn't it? I'm being recorded. Okay. All right. Register your votes again. I think we're okay now. There we go. Okay.
The answer is there.
I know, but register your votes anyway.
I didn't even see it.
You didn't see it, right? You had the blinders on. Okay. Oop, we get anybody else? Yep. Okay. We're missing somebody. Vanessa? Oh, okay. All right. Got it. All right, let's see what we have. Oh, okay. Good, but not great. You're going to see in all of the questions that I have that what I've tried to do is pick out stuff where there's a clear Florida difference, because that's what they're going to hit if they test Florida evidence. And you know, of course, under the federal rules that you can use a learned treatise as substance under a hearsay exception if the court determines, of course, it's a reliable treatise, and if it is read to or shown to the witness while the witness is on the stand. But Florida does not have a hearsay exception for a learned treatise. So in Florida, you can use the learned treatise to impeach, but you cannot use it as substance, which makes B the right answer. Any questions on that? Review these places where Florida is clearly different. All right, number 2. All right, we got everybody. Let's see how we did. Not so good. C is actually the right answer. Let's review what's going on here. And start first with, yes. Okay, start first with the federal rules. Under the federal rules, can a layperson testify in opinion form? Yes, if. What's the if? If it's within the knowledge of the layperson. So can I testify, wow, that car was driving really fast? Yes. Can I testify that it was going 67 miles an hour? Probably not, unless I'm Marissa Tomei in, wow, what's the name of that one? My Cousin Vinny, thank you. And remember, of course, to be an expert, which that movie illustrates really nicely. She had no degree, no nothing, but she worked in the shop, and she knew cars. So as long as you have the requisite expertise, you don't have to have a degree to be an expert. But a lay person under the federal rules can testify to opinion if it's something that lies within the general understanding of a lay person. In Florida, the rule is more restrictive. First of all, we view, when I say we, Florida, we view opinion in general as very suspect. So you always have to be careful with opinion. But C gives you the rule as it's stated in the statute. A layperson cannot testify in opinion form unless there's no other way for the layperson to testify. And honestly,
what that sentence is saying?
It's right out of the statute. And if you talk to people who are in practice, my sister used to do trial work, and she was really good at it. It's not that hard to characterize what you're looking for as something that can't be done any other way through an opinion. So that's how you kind of backdoor lay opinion.
You're basically saying that the witness is unable to say he was stumbling and slurring his speech. So instead, because they can't say that, they can say that in their opinion they were drunk, right? That's what that's saying. So it's very kind of broad.
Yep, exactly. As I say, my sister was real good at that. So just be aware. And they are going, and once again, they're going to test stuff like this. 2 reasons. Number 1, the rule is different from the federal rule. And number 2, if you're just learning kind of what I call half rules, and you sort of remember vaguely in your mind, oh yeah, you're not supposed to use lay opinion in Florida, right? A lot of you were thinking, but it's not exactly right. This is what the, and I went last night, I like to check the commercial outlines from time to time, and it's still stated correctly in the commercial outline, so you just have to read the whole thing to know the correct answer. Okay, number 3. Do we think we're all done? Oh, thank you. Okay, let's see how we did. All right, interesting division there. I gotta remember which question I'm doing here. Okay. That's interesting. Wait, did I get, I'm sorry. Yep, that's right. Okay. Let's take a look at what went wrong here.
What's the answer then?
The answer is C. Okay. Now, testing again the difference between federal rules and Florida rules. Marital privileges, they can be confusing, and therefore they will be tested. So we've got two, let's start with the federal rules again. Under the federal rules, we have two marital privileges. The first is marital communications. Spouses have to be married when? At the time the communication is made, and of course the communication has to be made in confidence. Who owns the marital privilege under the federal rules? Both spouses, okay? Florida follows the same rule for marital communications. So both spouses hold the privilege, which means Bonnie can prevent them from testifying because, okay, well anyway, Bonnie can prevent Clyde from testifying because it's marital communications, right? Now, the second kind of marital communication, marital privilege is spousal immunity. Under the federal rules for spousal immunity, when is it that the spouses have to be married? At the time the testimony is elicited. They don't have to be married at the time that a communication is made. Plus, spousal immunity extends beyond communications. Who owns the privilege under the federal rules? I'm sorry?
The one called testifying.
The witness spouse, exactly right. Florida does not recognize spousal immunity. So we have marital communication privilege, but not spousal immunity. Dean?
This question is a little vague. It didn't say if she was going to testify to something that he said to her or something that she knew, right?
Oh, okay. I see.
If that was the question, what basically the answer would apply.
Yeah, C's not the right, and I don't know why I'm reading upside down.
That's what Joyce came up with question 4.
Hey, yeah, I know. Okay, so we're doing, yeah, I don't know. Oh, you know what? It's D. Yeah, I circled this stuff just so I wouldn't have to read the questions again to block out the right answer. And I circled the C in Clyde, meaning D, but I circled the C in Clyde, so that's why D is the right answer. So I apologize for that. D is correct. Clyde can be compelled. And notice
That fills in the blank.
it fills in the blank. Exactly right. I apologize for that. It's just my own bad handwriting. That's why I was looking at it a little cross-eyed. Notice that this question is in an older style, which they still use in Florida. The fact pattern is vague. We add facts in the answer choices. The MBE does not use this style of question. It's one that they really don't want to use on the MBE portion. But Florida uses all these quirky styles. Yes, sir.
So Florida, one spouse can still prevent the other?
If it's marital communications,
Yeah.
yes. Because each spouse owns the privilege,
Okay.
right? So she owns the privilege in respect to matters told in confidence during marriage, marital communication.
Okay.
He does too, but she can prevent him. Even though he wants to testify, she can prevent him
As long as it's in confidence.
during the
only
marriage.
way she can prevent it.
Right, right. She could not prevent him from testifying as a witness about something that wasn't said in confidence if they were still married, because spousal immunity does not apply in Florida.
Okay.
Isn't there some very narrow exceptions to the CMC?
Yeah,
It's very narrow, but it's there. It's kind of quirky.
In-
I'm wondering if that holds over to the federal. I can't think of what it is right now, but it's
yeah, I'm trying to think of what
very
it,
narrow.
If you can recall it, then let me know, because then I can check that. Because right now I'm not thinking of what you're thinking, and it could be just that it's not coming into my brain, or perhaps I don't know that narrow exception.
You said that Florida follows the marital same as does, and I
Yes.
can remember, so communications made prior to the marriage would not?
Correct. The communication, for marital communications, the communication has to be made during the marriage and in confidence. So if you go out to dinner with your spouse and you're talking at a table with other people present, even though you're married, it's not, the statement's not made in confidence, it's not protected. So it's got to be in confidence. Okay, and I apologize again. That's my own bad handwriting. D is definitely the right answer here. Okay, number 4. All right, see how we did on this one. This time I know I'm marking the right one. We were all over the board on this particular one. So, and I promise you that's the kind of thing they'll test if they test Florida evidence. So we have it's a 2-step question, and you have to get both parts right, which makes it a more difficult question. First step is the statement. What is it? Some of you thought it was a declaration of against interest. Some of you thought it was an admission. Which one is it? It's an admission. Why is it an admission? Because she is a party. Now, in that respect, admission versus declaration or statement against interest, Florida is just the same as the federal rules. How we treat an admission, I'm going to hold that off because we'll have another question. But in terms of which is which, Florida law is the same as the federal rules. So we have an admission, which means you could get rid of A and C. Now we're down to B and D. Under the federal rules, there is a patient-physician privilege weak, but there is one. we do not, in our Florida Rules of Evidence, have a patient-physician privilege. We have privileges for just about everything else in the world, but we don't have patient-physician, number one. Number two, of course, you still have privacy issues with medical records, but all you need in Florida is that subpoena, and that privacy issue dissolves. So that makes D the right answer. It's an admission, and the subpoena will force the testimony. Any questions on that one? Because once again, it's so testable. All right, number 5. All right. Not so good. Okay, another place where Florida differs from the federal rules, because you can impeach with bad acts, right, under the federal rules. Of course, with impeachment, when it's a bad act and not a conviction, if you ask the witness, did you write a bad check, and the witness says, no way, no how, you can't use extrinsic facts to prove that the bad check was written. In Florida, you cannot impeach with a bad act. You can impeach with a conviction, but you cannot impeach with a bad act. It doesn't mean you can't get the bad acts in Florida. How do you get bad acts in Florida? At least in a criminal proceeding. How do you get bad acts in a criminal proceeding under the federal rules, besides impeachment?
On cross-exam.
Sounds like mimic?
Oh, motive.
Yeah. Mimic rule, motive, intent, absence of mistake, identity, and common scheme or plan, right? Oh, yeah. We have a mimic rule in Florida. Although the evidence, it has to be strikingly similar, I think, is the correct vocabulary. I mean, it's got to be really close.
Thank you.
Okay. So those bad acts that you can't use to impeach in Florida, you can get in through the mimic rule in a criminal proceeding. I'd suggest that we review these distinctions, because there's a real good chance that you're going to have Florida evidence on the exam. All right, number 6.
So that was C was the correct answer.
Yeah. No, for number B.
B.
B, because Florida rules do not permit. Do we think we've all voted? We're missing one. Okay. Oh, there we go. Okay. All right. Now that's the result we want to see. Yes. So remember, of course, under the federal rules, you can impeach with reputation or opinion. In Florida, I mentioned earlier, we're very suspect of opinion testimony. And so you impeach with reputation, but not opinion in Florida. All right, number 7. All right. See how we did? Another place, of course, where Florida is different from the federal rules. Hearsay exception. It's a two-part, of course, it's a two-part question again. Franny's charged with murder, and Seymour wants to testify that she exclaimed, "I really shouldn't have killed Zoe." It's an admission, right? Because she's a party opponent. And under the federal rules, an admission is admissible non-hearsay. But in in Florida, it's admissible hearsay. All right, bringing up the rear, number 8. All right. "50-50, but B's the right answer." Florida rule again. Under the federal rules, of course, habit evidence is admissible, right? Period, end of story. In Florida, we make a distinction, first of all, between business and personal habit. For business habit, it's admissible, no corroboration requirement. But for personal habit, we follow the old common law rule, which we do to a certain extent in other areas. The hearsay exception for admission is another example. Common law rule is what you have in B. Habit evidence is admissible, but only to corroborate other evidence. Okay, so hopefully you get an idea now of the distinctions that you want to have in your brain. And a real good chance you're going to see Florida evidence, so make sure you review these distinctions. Any questions? Okay, then let's take a little break, and when we come back, we'll do the Florida con law question. Okay, let's go ahead and get started again so we can finish up and you guys can go home and study some more. All right, the last question we're going to do today is a Florida con law question, but it has a lot of stuff in it, and I wanted to do at least one question that had multiple topics combined, because I focused most of the ones we've been doing on single subjects for a reason. But of course, you know, they can test up to 3 subjects per question, and they're doing it. So this question was labeled as Florida con law and Florida wills, but it's got property in it too. You know, so it could have had pro rep in it. This one doesn't. I just want to point something out to you. I don't know if they mentioned this particular statute in your commercial courses, but we have a new statute that was effective in October 2013 that embodies the professional responsibility prohibition against drafting a document with a gift to a lawyer. Anybody mention that statute?
Yeah.
Because the statute, it's the same rule. That's the good news. The lawyer can't make a gift to draft a document with a gift to himself unless, obviously, you have the exception for close family members. But generally speaking, yeah, it's the same rule. So I don't want you to get scared. It's exactly the same rule. But what the statute says is the gift is void. Now, remember, the professional conduct rule prohibits the attorney from drafting the document. The statute actually says the document or the portion that makes that gift, to be more precise, is void. So beware of that. And the reason I raise it is it just sort of seems to me it's a nice way in a question like this one that has a will and it's got some other stuff going on that you could slip professional responsibility in with a new angle. And of course, they're always looking for new and interesting angles. Okay, so let's take a look at this question. Turn to the back. You got the fact pattern. I also picked it because it's Homestead, and they do like to test Homestead. Last time they did what I call how a bill becomes the law, all that stuff, single subject, access to courts, equal protection, stuff like that, which is a favorite topic. So make sure that you can answer a question like that. But another frequent flyer is Homestead. They love it. And the good news about Homestead is that you can have a structure in mind. Before you go in, you know how to write about Homestead. It makes life a whole lot easier. So let's take a look at how we're going to structure this question. So it's an older question, but I have updated the answer with all and any recent changes in the law included. In 1968, Mr. Adams inherited a home. It's situated on 1 acre of land in the city of Miami-Dade. Well, right now, you know, when you see it 1 acre of land in the city, you're thinking Homestead, too much. You get up to a ½ acre, right, in the municipality, 160 outside, but ½ acre inside. Mr. Adams married Mrs. Adams in 1970, and they lived in Mr. Adams' Miami home. You could see how easy it would be to combine homestead with family law. Another thing, that they go very well together. Or trusts. We don't have a trust in this question, but real easy to combine it with trusts too. The couple had 2 children, son Sam, born in 1971, and a daughter, Dot, born in 1983. At the time of this question, Sam's going to be an adult and Dot is a minor. Significant because Mr. Adams is going to die, survived by, well, the spouse is going to disappear as we go through here, but the minor child, yeah. So remember that rule for homestead. In 1992, Sam obtained a job in Wisconsin and moved there. So, Sam's kind of out of the picture for homestead purposes, maybe not for other things, but certainly for homestead. Mr. and Mrs. Adams' marriage was dissolved in 1993. Under the divorce decree, Mr. Adams retained ownership of the home, and so it can still be his homestead, right? Decree permitted Mrs. Adams and Dot to occupy the home rent-free until Dot reached the age of majority or until Mr. Adams died, whichever came first. Now, they're setting up something that I'll talk about a little bit later, but she, the wife, is living in the house, and Mr. Adams has got to live someplace. So kind of think about that for a moment. And here we go. In 1994, Mr. Adams bought a 1-bedroom condominium located in unincorporated Orange County, Florida. Well, it's a condominium, so you're not going to have 160 acres, I don't think, with your condo. But remember, 160 acres outside a municipality. He moved into the condo and lived there alone for 2 years. He's living in a condo in Orange County. Mrs. Adams is living with Dot in the house in Miami-Dade County. 2 homesteads. And it's possible to have 2 homesteads if one is the owner and the one home, if you will, is the owner's home and the other is the owner's family's home. So there's stuff that's been written about that, and it is a point that I've discussed with Judge Shepard, and yeah, that's what they're wanting you to discuss here. And Mr. Adams should be able to have homestead in both of those houses, the house and the condo, at least while he's living in the condo. Yeah. In 1995, and it says the root, it means the roof, that's just a bad scanning job, sorry about that, of the Miami home needed replacement. Mr. Adams obtained an unsecured loan, ding, 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 from XYZ Bank to pay for the new roof. Why do I say ding, ding, ding if it's unsecured?
Oh, okay, credit.
Yeah, it's not attached. And remember our exceptions in respect to creditors for homestead. Secured, yeah. So taxes, it's anything that grows out of. So taxes, your mortgages, and then your mechanics liens. But this particular loan is unsecured, and so it's not going to be an interest that can be recovered from the homestead. In 1996, Mr. Adams moved back to Miami, which means if he established a homestead in the Orange County condo, he did what to that homestead? Abandon it. You want to be careful about abandonment because the law is going to presume there is no abandonment, but if he moves away and never goes back, that's pretty good evidence of abandonment. Always look for the intent. And he lives in a rented apartment. During that period, his condo was vacant. They're trying to set up abandonment there. And he lists the condo for sale with a real estate broker, but no buyer was found. All of those are facts saying, hey, I don't want this property anymore. It's not my homestead. He died in an auto accident in 1997. His validly executed will devised all of his property to his brother Bob. So right away, bells and whistles again. It's homestead. Can he devise to Bob?
No.
Because? Minor child, yeah, right. And he's not survived by a spouse anymore, right? Why? Because he's divorced, okay? Don't forget. Mrs. Adams is living there, but she's the ex-Mrs. Adams, if you will. the estate's only significant assets were the condo and the Miami home. So you're going to have to decide if that condo ever was or still is protected homestead. Mr. Adams was uninsured at the time of the auto accident. Victim, the other person involved in the accident, filed a timely lawsuit against his estate and obtained a final judgment based on injuries. Is victim going to be able to attach the homestead?
No.
Not the homestead. Anything that's not homestead, he can attach. Now, here's the part where the question is a little old-fashioned. Discuss the rights of the various parties to Mr. Adams' condo and his Miami home. Kind of vague. But we know where we need to go with this question. So let's take a look at how we're going to break it down. And, oh, question? Yeah.
I'm reading it and like, where do we start?
Where do I start? First thing I'm going to do is I'm going to establish the homestead. And then I'm going to dispose of his property once I've figured out what the homestead is. Because you can't dispose of his property until you decide if there is a homestead, and if so, which property is it, and how much of the property. Because if it's the Miami home, it's just half, because it's a full acre. So establish the homestead. We got to identify it, and then your procedure for claiming. I kind of throw that in. It's not a big deal, because you really don't have to do anything in Florida unless and until you're pushed into it, to formally establish the homestead for the purposes that we're talking about here. For your tax exemption, for your $25,000 tax exemption, yeah, then you have to file. And that filing would be sufficient to satisfy any procedural claim. But the key here is going to be identification of the homestead.
I think they've increased it, have they not, to 50,000?
For seniors, you get $50,000.
It's 25,000. It's 50. If it's two people, you get 50.
Well, if it's two people, yeah, and if you're seniors, you get the extra.
Oh,
If
for
you're
single people, is that what you think?
But
and
single people is 25.
25 for single, yeah.
For married?
Right. Yeah, I'm sorry. Okay, yeah. The individual gets 25. You get an extra 25 if you're a senior. Veterans get an extra, I think. I don't quote me on that one, but I'm pretty sure they get the extra too. And when it comes to homestead, remember and I know Judge Shepard talked about this, there are different issues. Theoretically, the definition for homestead is supposed to be the same across the board, but sometimes maybe not. So you want to know if it's protected from creditors during the lifetime of the owner. That's one issue. You want to know if it can be devised at the owner's death. That's number 2. And number 3, you want to know if the homestead protection inures to the person who takes the property. And when I say homestead protection in respect to the owner inures to the benefit of the person who takes the property after the owner's death. So those 3 things should be in your mind. There are 3 issues that can come up with homestead. And as I said, the case law tells you, although they don't always follow this rule, you should use the same definition for any one of those 3 things. So, property owned by a natural person. Mr. Adams is a natural person, so that's the good news. Used to say head of the family, doesn't have to be head of a family anymore. A single person, for example, can have homestead. But you have to be a natural person with an asterisk, of course. And I know Judge Shepard talked about this particular issue. What if the homestead is held in a trust? Well, there's case law in Florida, some of it written by Judge Shepard, I do believe, that says that it's okay. You still have homestead protection. And the elective share statute specifically refers to homestead that might be held in a trust as okay. But there is some authority from bankruptcy courts sitting in Florida that suggests that, at least in respect to protection from creditors, that if the homestead is held in a trust, that it's not protected, because it's not the trust isn't a natural person deemed.
Can you inure, I don't know if that's the right word, the homestead to, say it's somebody, it's a husband and wife, the husband, it's his property, it's not a tenancy by the effect. The wife is the head of household by making, what is it, 60% of, is there a definition for head of household, like makes 60%? No?
Yeah.
Can I see that somewhere? Okay, I'm way off and forget.
Okay, I don't know where you're going, so I don't think, I mean, I don't think
So
so.
the household is just not even considered at all.
Well, yeah, you don't, yeah, the old statute used that language, but notice that it's been changed, or the Constitution's been changed. So don't worry about head of the household in this context, yeah. Just be a natural person. Just, remember, put in the back of your mind, if they give you a trust, and it's likely to be a revocable trust, if the owner sticks the homestead into a revocable trust, at least address the issue. And if you decide that it's okay, then, at least explain why. There is case law. You could refer to the elective share statute as proof that the legislature is thinking it's protected. Or if you decide it's not, then refer to the bankruptcy cases that say it's not. So, but look at what we're doing with homestead. Break it into pieces. So what is homestead? It's property that's owned by a natural person. And it doesn't have to be a fee simple interest. It could be a life estate. It could be a long-term ground lease. It certainly could be property that's held in tenancy by the entirety. There are a lot of variations on what kind of property is entitled to homestead protection. Second, we look at the location. Is it inside a municipality or is it outside a municipality? If it's inside a municipality, it's up to 1/2 acre. And of course, we have an issue here because the Miami home is on 1 acre, so only 1/2 is going to be protected. And what are they going to do in practice? They're not going to draw a line through the middle of the house, so you would carve out the 1/2 acre that has the house on it. If we're talking about outside the municipality, it's 160 contiguous acres, including improvements. And there's actually a little bit of varying case law on those improvements. Some cases, there's a case that I'm thinking of that involves a mobile home park on the acreage, and the owner lives in part of the 160 acres, and the rest is developed in, for a mobile home park. And there are some cases that say that as long as the owner lives on that property, even if there's commercial enterprise on the rest of it, but it's contiguous, that it's still all protected. Other courts have said, no, your protection doesn't extend to the portion of the 160 acres that's commercially developed. So that's kind of left open. Here, the only thing that's outside a municipality is the Orange County condo. And as I said before, I can't imagine any way that Orange County condo would include 160 acres of contiguous land. So, number one, identify who owns it, your natural person. Number two, the location and the size. And then number three, it's got to be used as a permanent residence. And that's where we get into the issue of whether we could have 2 homesteads in this case. So the main home clearly is used as a residence of the ex-Mrs. Adams and Dot. The question is whether it can be a homestead for Mr. Adams, who's not living there, right? Because he's not there. But his ex-spouse and his daughter are there. And I give you some citations here. Not that you have time to look this stuff up, but there is authority, a lot of discussion on the issue. And yeah, probably the whole purpose of the homestead statute is to protect the family. And so if you don't protect the Miami home, even though he's living someplace else, Mrs. Adams and Dot could get the property sold out from underneath them. So the policy would suggest you protect that property along with the Orange County condo while he's there. Then, of course, we have to consider abandonment. It's the exception, not the rule, but it's possible for abandonment to occur. You need evidence of the owner's intent, and it's got to be pretty strong evidence, which I think they probably gave you here. I mean, they were piling up the facts. He moves away. He puts it up for sale. He never goes back. He doesn't do, or think anything about it. So, yeah, I'm guessing they probably were wanting you to think that he abandoned the Orange County condo. But honestly, as long as you mention the issue and explain your conclusion, any factual conclusion, as long as you justify it, is going to be okay. And remember, because I've seen them test this particular point, temporary absence is not going to be abandonment. So if he had purchased the Orange County condo, set up home there, and then decided to drive down to Miami, for a couple of months to visit with his daughter, he wouldn't necessarily have abandoned his homestead because he's intending to go back to Orange County. And just a couple of cases there. So in this case, what do I think? I kind of think you do have a homestead in the Miami home because the family's there. He started out with a homestead in the Orange County condo, but he probably lost it. And notice also I added some additional facts. Remember when he got back down to Miami, he realized the roof was leaking and he fixed it. Well, why are you going to fix it if it's not something that you value as your homestead? I think that's more evidence that shows that he certainly wasn't abandoning the Miami house that his family was living in. Now, Orange County, we kind of already went through that one, so we can go past that. Okay, remember, and you just throw it in, because I never see it make a difference in the cases, to be honest. But in addition to your real property, there's a $1,000 personal property homestead exemption, which is different from exempt personal property under the probate statute. So just mention it and then move on. Okay, so remember with the procedure, I mentioned it. I don't know that I would spend a lot of time on the exam talking about it because once again, it's usually going to be your homestead unless somebody proves it's not. But you could, through the filing of a petition, establish it, or quite frankly, usually just look to see if the tax exemption has been claimed. So now we've determined what's the homestead, and now we distribute the property. We have to look at the devise of the Miami home, devise of the Orange County condo, any claims of creditors, because they give you creditors, and procedure for satisfying those claims. So we start with the devise of the Miami home. I decided it was homestead. If it's homestead, we know that it cannot be devised if the owner is survived by a spouse or a minor child. In this case, that's a minor child, so the devise can't occur. We don't have a spouse again in this case because she's an ex-spouse. Now, if the property can't be devised, what happens to it? Then it will descend, right? Who does it descend to? If you have a spouse, it's one of two things. It goes to the spouse who gets a life estate, followed by a remainder per stirpes in the lineal descendants in being at the death of the owner, or a relatively recent change, the spouse gets the option of electing to take as a tenant in common with the surviving kids. And if the spouse elects to take as a tenant in common, the spouse gets half and the surviving kids get the other half. But there's no election here because Mrs. Adams is the ex-Mrs. Adams. So who's going to get the property? Is it just Dot? Nope, it's Dot and Sam. Because while the prohibition against devise depends on Dot being a minor, remember, it goes to the, if there is no devise, which we can't have in this case, it goes to the lineal descendants. They do not need to be minors. So, in this case, Dot and Sam are going to take, and they take as, here's your property, tenants in common.
Excuse me, when she took this tenant in common, can she not sell at that point? Wasn't that part of the change in the law?
Can she, I'm sorry, not what?
Could you not devise the property at that point in time, when she went?
Oh, the spouse? Sure.
Yeah.
Oh, she can. But the surviving spouse can. But he, Mr. Adams, as the original owner, he can't devise because there's a minor child. But once the property goes to Mrs. Adams,
That's in it, yes.
then she can do what, now, if she establishes it as her own homestead, which she might well do, then the homestead rules apply to her. But if she doesn't establish it as her homestead, she can devise it, her interest to whomever she wants.
But it went from she became a tenant in common with her daughter?
Yeah.
And so
And no, well, she would have been a tenant in common with her daughter and her
and
son. Mhm.
But she had the ability to devise the property at that point in time.
Unless she established it as her own homestead.
I understand.
Yeah. Dean?
Now, the conditions, or the options you talked about, either taking a life stay with the remainder of the land, or taking the undivided one, that only applies if a devise fails. If he attempts to devise it.
No, well, the devise will fail if there is a surviving spouse or a minor child.
If he doesn't do anything, doesn't try to devise.
If he doesn't do anything, she still has that option.
Still, so she doesn't get a fee absolute.
No, she does not.
Okay.
She has either option available to her. Absolutely correct. So remember that prohibition on devise says Mr. Adams can't, he can execute the will, it's just that the provision won't be effective. But even if he decides to die intestate, she still gets that option, right? Okay. Assuming, of course, she's not the ex-Mrs. Adams. She's got to still be the spouse. And/or I've seen questions, and one question that I use from time to time, there's a surviving spouse, but she waives her homestead protection. Remember, all your statutory protections can be waived in a pre- or a post-nup agreement. So if she waives her protections, same thing again, right? Now, he owned the property by himself here. I think it said that he did, or was it vague here again? No, he inherited a home. I just mentioned the tenancy by the entirety rule here again, study guide. I wouldn't put it in my answer because it tells you specifically he inherited the property. But should there have been a tenancy by the entirety? It's a point that students get confused on. That's why I include it. If there is a tenancy by the entirety, it can still, of course, be homestead property, and usually is. And so protection from creditors still attaches. But if it's tenancy by the entirety property, that rule about devises is a non-issue. Because if Mr. and Mrs. Adams had held the property as tenants by the entirety and hadn't divorced, of course, so there was still a Mrs. Adams, she would take the whole thing by the right of survivorship. Then she gets the whole thing because it's a tenancy by the entirety. And she wouldn't have to share it with the kids because it started out as tenancy by the entirety. So just be aware of that rule. It's not relevant to this question, but easily tested, and as I say, something that students oftentimes get confused about. Okay, Orange County condo, I decided that it wasn't homestead anymore, just so I could contrast. Quite honestly, it makes a better answer to the question. But you decide whatever you like. If it's not homestead anymore because he abandoned it, then of course Bob gets it. And notice something. If you think back to last week when we did the trust question, what rule did I tell you? When in doubt, give everything to Bob, right? Bob always, I'm telling you, in all these questions, Bob always makes out like a bandit. So take care of Bob. So Bob would get the homestead, of course, subject to certain creditor claims. And we need to consider, of course, a devise of homestead property, if it had been homestead property. But it had been divisible because let's suppose that there is no Mrs. Adams because they're divorced and Dot's an adult. Then, of course, Mr. Adams could have devised the property to whomever he chose. The question is, homestead protection, his homestead protection from his creditors, could it inure to the benefit of his devisee? And the answer is it depends. Anybody know what the depends is? If his devisee is what? If his devisee would qualify as one of his heirs at law. Who qualifies as an heir at law? Anybody in one of the first three parentellas, right? And was this his brother Bob or his friend Bob? Brother Bob. Brother Bob, would get his homestead protection. You do not have to be the heir, because the heir here would be the spouse and/or, well, it would be the spouse under the new law, or if there's no Mrs. Adams, but you got a child, Dot, and Sam, they would be the heirs, but Bob could be an heir because he could possibly inherit as a member of the second parentela. Okay, don't forget about your family allowance, $18,000, right? Which will go to the surviving spouse, of which we have none here, and any lineal ascendants and descendants that, and here's where Sam is at least an issue, any lineal descendants or ascendants which the decedent was obligated to support or actually supported. Well, he's obligated to support Dot, but he's not obligated to support Sam anymore, and he didn't actually support Sam. So the family allowance would go to Dot, and remember, it's class 5. We'll talk about that later. Right there, Dot, she gets the up to $18,000. An exempt personal property set aside. Remember, you get an exempt personal property set aside in Florida. Your household furnishings, and now they changed the rule, only 2 cars. You used to get all the cars. And now just 2 cars used for personal use of the decedent or the family. It's got to be in the decedent's name, and the car can't exceed 15,000 pounds. I don't really know which cars they were thinking about there, but apparently that can be a pretty decent-sized vehicle. And I don't know why I didn't put it up there, but up to $20,000. It goes to the spouse if you have a spouse. Otherwise, it goes to the lineal descendants. That's Sam and Dot in this case. Now we get to the claims of creditors. Who are the potential creditors? We've got the victim from the automobile accident and XYZ Bank. I decided that the Orange County condo wasn't homestead, so it's fair game for both of them. What about the Miami home, which I decided was protected homestead? We've got, okay, we'll go past that. Sorry, what about victim's claim in terms of the Miami home? If it is homestead, no, it doesn't fall into the 3 categories that we talked about. The tougher issue is whether the bank's loan falls into these 3 categories, and the answer is it does not. Because first we've got taxes and assessments. Obviously, the bank's loan doesn't fall into that category. Then you see the second category, obligations contracted for purchase, improvements, or repair. And you're thinking, well, he was repairing the roof, right? But he borrowed money and then paid the roofer, or didn't pay the roofer, right? It's not secured. And because it wasn't secured, it can't fall into that category. And then you say, well, what about the workers? Well, the workers could come against the property, mechanics lien, but that's not the issue here. The bank's not doing the work. The bank supplied the money. So the answer is that loan, unsecured loan from the bank, does not fall into any of the 3 categories, and therefore it should not be something that can be recovered from the homestead. Now, there is something, I'm going to go forward here. I threw this in. There are cases in Florida that talk about an equitable lien, particularly if you have some fraud involved. It's more a study guide than anything else. There is case law. I don't think this is a case that merits an equitable lien, but once again, just something for you to think about. So now, what about the procedure? When are these folks supposed to file. Here we got a little bit of wills administration that comes into play, and they could very easily give you wills administration on this exam, so make sure that you review that procedural stuff, which you would not have covered in any detail in your wills and trust class, no matter who you had, including me, because it's boring stuff and we never teach it. So you were supposed to, as a creditor, file your claim within 3 months after the date of first publication of the notice of administration, or 30 days after the service of notice to you. And of course, the personal representative has to serve personally any and all known creditors. That's a due process issue. You publish in the newspaper to cover anybody you don't know about, but you have to serve personally anybody you do know. And if you don't file, it's kind of use it or lose it. The facts do tell you that they filed timely claims. So that's the good news. They didn't make you have to deal with that particular issue. So who gets paid first? And important, not so seriously important in this particular question, but I promise you, if you get wills administration, you want to know the classes of claims in Florida. And it surprises me how often it shows up in the essays as well. So class 1, easy way to remember what class 1 is. We always take care of ourselves first. What can I tell you? Cost of administration, personal representatives, and there we are, attorney's fees. Always take care of ourselves first. Second, reasonable funeral and interment expenses, but not to exceed $6,000. And unfortunately, that's really not a lot. So it's the first $6,000, because when we get down to class 8, of course, we have a catch-all. This one always amazes me, class 3. Taxes are class 3, not class 1. How the federal government allowed themselves to be subrogated to the attorneys, I really can't tell you, but there it is.
So they're all attorneys, I think.
Yeah, they're all attorneys, right? Okay. And this part here, it used to be just debts and taxes. A couple of years ago, I can't remember exactly when, they added Medicaid and those other claims. But the main focus here is the taxes.
So it's us, the dead, and then the government.
Yeah, kind of interesting, isn't it? Yeah, you would think it would be the government first, and then the dead. But class 4, they like to test this one. So your reasonable expenses from the last illness, from the last 60 days of the last illness. Anything that exceeds the 60 days falls down to class 8. Class 5, that's your family allowance up to $18,000, as we just discussed. Class 6, a relatively recent, although it's been there for a while now, addition, arrearage from court-ordered child support, because we don't want the kids to go wanting. Class 7, debts acquired from the continuation of the decedent's business. And then Class 8, your catch-all. Anything else, like judgments that are rendered against the decedent during the lifetime, and the excesses in the funeral expenses and last illness expenses. So here, victim in XYZ Bank, they're all the way down at the bottom because they are judgments. Judgments and liens. The bank actually didn't have a judgment, did they? Or I think they just have the loan.
Just an answer.
Yeah, just an unsecured debtor. But nevertheless, they would both fall into Class 8, and they would be paid pro rata.
They said they had filed a timely claim.
They filed a claim against the estate, but they didn't have a judgment. But it doesn't matter here. They still would fall into Class 8.
Just a universal question. I know you said that all the questions today, but it's discussed the various claims on them in the house. So we got here in the wills because some of the creditors would not be able to take for the home. So then you're like, oh, well, there's some mistake. Maybe I can go on to that.
Yeah,
That's
right.
the leak you have to make?
Yeah, well, I'll tell you why I put it in. That part is not just study guide, because they gave you facts. I always like to use the facts. They put them there for a reason, and that was the reason that I made out of the facts. Because you've got those creditors, and are they just going to go without anything? Well, no, here's how they get paid. Yeah, right. I understand. And I can't tell you, I didn't write this question. I obviously have not seen the grading outline for it. But my guideline is always, if there are facts, use them. And in a vague call to question like that, that's how I use those facts. Okay, any questions? I don't think I stuck anything on the end of this, did I? Oh, payment, yeah. Oh, yeah. Just to remind you on this particular point, if you're going to sell the real property, the condo in Orange County, for example, to pay off these debts, the question could arise. It's not tested directly in this question, but I've seen it tested in other essay questions. Can the personal representative sell the property? Not without one of two things. If the will authorizes the personal representative to sell property without a court order, then the personal representative can do so. Or if the personal representative goes to court and gets court authorization. So in this case, we don't have any evidence that the will authorized sale without court authorization, so your personal rep needs to go to court. And remember, if it's homestead property, no matter what, personal representative has to have court authorization to sell homestead. So then I just summed it up and threw in some stuff. You wouldn't necessarily have to go into all the rest of this. Abatement of claims, little bit of review of Will's procedure, stuff that you would really want to know, though, if they test in multiple choice. Okay, questions, comments? That's it for today. Okay, now, for those of you who are not coming on Wednesday, good luck. And it's always a pleasure to see you when you return to STU Law, just hopefully not in this class. For those of you who are coming on Wednesday, if there's anything in particular that you want me to talk about in the time that we have, then send me an email. And when I say anything in particular, subjects that you say, wow, please, make sure that you talk about homestead or whatever. Okay, that's it. Feel free to send me questions, send me essays. But if you're sending me essays, don't wait too long, because it's not going to be of much value to you, to be very honest, if you wait till the end of next week. Okay, that's it.
Thank you very much.
Good luck. Good luck. Good luck.